Phala Phala report is finally out, and things, well, they just got very interesting. The Section 89 independent panel sought to preliminarily investigate whether there was sufficient evidence to justify impeachment proceedings against the president as a result of evidence provided by three opposition parties, these being the African Transformation Movement, the United Democratic Movement, as well as the Economic Freedom Fighters. And this all arose from the housebreaking and theft that occurred at the president's Phala Phala wildlife game farm. The conclusions reached by the panel have unleashed a firestorm as opponents of the president have called for his head in resignation, whilst the president has taken the report on judicial review. Which side will ultimately prevail in this protracted legal battle? Well, let's take a closer look at another one of Lolo's takes. Like most of this country, I too have also been glued to the news looking for analysis and updates on the fallout from the Section 89 independent panel's report into the robbery at the president's Phala Phala wildlife game farm. Having found that on a preliminary review of the evidence brought before them by three opposition parties, firstly the African Transformation Movement, secondly the United Democratic Movement, and thirdly the Economic Freedom Fighters, the panel found that the president did indeed have a case to answer for on all four charges or allegations. Resulting flurry of activity, with the president at one moment looking like he's going to resign and in the next taking the report on judicial review. Regardless of which side of the pond you might sit on this, I think this matter raises some serious issues which require some serious questions for our country, and also there's some interesting legal questions which I believe deserve some thorough legal debate. Now, before we begin, please take note that this is not some kind of partisan analysis. I'm not looking to provide talking points or arguments on whether I believe the president should resign or not, or whether and the kind of impact that this resignation would have on the country, whether politically or economically. At least for the sake of this video, I'm a lawyer first, and that is the perspective I wish to bring to you. Furthermore, please note that nothing in this video constitutes legal advice, and this is purely for educational and entertainment purposes. There has been a lot of discussion on numerous mediums about the facts of what happened, as well as the Section 89 independent panel, how it was constituted and what kind of findings it came to. I would like to delve a bit deeper into the charges as well as the findings and the reasoning of them in order to fill what I believe to be a gap in the conversation, or a lacuna as we call it in the legal world. Now, let's think like a lawyer, and this means establishing the pertinent facts, finding the applicable law, and applying it to the facts in order to make a legal assessment. In terms of the first part of this equation, this whole fiasco began with a sworn statement and affidavit by former senior spy Arthur Fraser, laying criminal charges on the president on 21 June 2020. This resulted from and was subsequent to a break-in at the Phala Phala wildlife game farm on 9 February 2020. Arthur Fraser accused the president of crimes such as money laundering and corruption. The break-in resulted in the theft of an unconfirmed amount of foreign currency, with evidence indicating amounts ranging from $580,000 all the way to $800,000. Now, the independent panel's account suggested that after reporting the incident to them, the president's personal protection unit subsequently resorted to its own investigation, arising allegations against the unit and its leader, General Walter Rude, of kidnapping and torture in pursuit of the stolen money, which actually spanned two different countries. The circumstances spelt out by Mr. Fraser and subsequent statements by the president relating to the allegations prompted further investigation by various state and governmental entities such as the South African Reserve Bank, the South African Revenue Service, the Public Protector, the Department of Home Affairs, etc. These allegations also prompted consternation amongst elected representatives, resulting in the African Transformation Movement by way of notice of motion instituting Section 89 impeachment proceedings, which established the Section 89 independent panel that would preliminarily investigate the allegations and evidence proffered by ATM and parties supplementing these allegations such as EFF and UDM. The investigative panel comprised Justice Sandile Ngcobo, a former Constitutional Court judge, who chaired the panel, Justice Thokozile Masipa, a retired High Court judge, and Advocate Mahlape Selo, SC. These people were tasked with producing a report of preliminary findings based off the allegations and attached evidence submitted by members of Parliament concerning the question of whether sufficient evidence was presented to show that the President committed a serious violation of the Constitution or law, as well as further serious misconduct, thereby justifying the removal of the President. These represent two of the three grounds for the removal of a President in terms of Section 89(1) of the Constitution, eventually by the way of a 2/3 majority vote in the National Assembly. The final requirement relates to a President being unable to perform his or her duties as a result of infirmity and something of the kind. In terms of the functioning and powers of the panel, Section 129G of the Rules of the National Assembly most importantly indicated that the independent panel is permitted to afford any member of Parliament the opportunity to place relevant written and recorded information relating to the inquiry before the panel, allow the President the opportunity to respond in writing to all these allegations made, investigate the matter purely on the relevant written and recorded information placed before it by members of Parliament without the opportunity to summon oral testimony. Upon the conclusion of this investigation, the panel was required to produce a report detailing its findings as well as the reason for these findings, concluding with any recommendations regarding the progression to an impeachment inquiry, which would require the panel finding that the President had a case to answer for the allegations termed as charges found against the President. There were 4 allegations termed as charges in the report made against the President for the purpose of his impeachment. These were investigated by the panel and included, firstly, that the President seriously violated the Constitution in infringing Section 96 subsection 2 subsection A, read with the obligation arising from Section 83B by engaging in other forms of paid work, and this was from being the sole member of the closed corporation Dabanyoni Estates CC, which was the operating entity for the Phala Phala game farm. Secondly, that the President seriously violated Section 34 subsection 1 of the Prevention and Combating of Corrupt Activities Act, which is abbreviated as PRECA, as many of you would have heard, by reporting the housebreaking and theft at his farm to the head of the Presidential Protection Unit, General Rude, instead of the required Directorate for Priority Crime Investigations official as required by legislation. Thirdly, furthermore, that the President seriously violated the Constitution by infringing the aspect or certain aspect of Section 96 subsection 2 subsection A, read in line with Section 83B, which requires senior government officials not to place themselves in a position where their official obligations would conflict with their private interests by unlawfully instructing, once again, to investigate the already mentioned housebreaking and theft. And finally, that the President engaged in serious misconduct by violating Section 96 subsection 2 subsection B of the Constitution, or at least an aspect of it relating to the requirement that government officials may not engage in conduct inconsistent with their office. This was read also with Section 83 subsection B of the Constitution. Once again, this is all in relation to the instruction to General Rude instead of following the required legal process. From a careful reading of the charges, 2 specific phrases appear predominantly arising from the grounds listed in Section 89 for impeachment, which we discussed earlier in this video. And these are a serious violation of the Constitution or law, as could be seen from charges 1, 2, and 3, and secondly, a serious misconduct, as could be seen from the 4th and the final charge. And now, because it's unclear of the parameters to be considered in establishing whether allegations cross this required threshold for impeachment, the parliamentary rules in terms of Section 89 go on further to define these. And they explain that, firstly, a serious violation of the Constitution or the law means behavior by the President amounting to an intentional or malicious violation of the Constitution or law performed in bad faith. And serious misconduct as being unlawful, dishonest, or improper behavior performed by the President in bad faith. Now, these definitions should always be kept in mind as we further investigate the law and its application in this matter. This is because, as stated by the panel, what is implicit if not explicit from the Constitution and the rules is the recognition that not every violation of the Constitution or the law or misconduct constitutes a ground for impeachment and removal from office. The line between violations that are tolerable and those that are intolerable is delineated by the seriousness of those violations or misconduct. It is through this framework of the definition, the seriousness of the allegations, and the rules and the powers of the panel, the conclusions and any misgivings about them should be understood. Before we dig a bit deeper into the findings, there is another phrase found in both of the definitions I just mentioned, which I think is worthy of more investigation, and that is bad faith, or mala fide as put in Latin. Bad faith is defined as acting with the intent to deceive, and it is the opposite of bona fide, or good faith, which means to act honestly and fairly in dealing with others. So, not only was the panel tasked with establishing whether there was sufficient evidence to justify an impeachment inquiry in terms of the allegations made by the opposition parties, but there had to be sufficient evidence that this conduct was undertaken with the intent to deceive. This was spelt out by the former Chief Justice, Mogoeng, in the case of the Public Protector versus the South African Reserve Bank, where he stated in a minority opinion that the correct approach to determining the existence of bad faith is therefore one that recognizes that bad faith exists only when the office bearer acted with the specific intent to deceive, harm, or prejudice another person, or by proof of serious or gross recklessness that reveals a breakdown of the orderly exercise of authority so fundamental that the absence of good faith can be reasonably inferred and bad faith presumed. One final central issue, which was explored by the panel but didn't quite neatly fall into the charges made against the president, was with regard to the source of the funds, which is subject to the alleged theft. It is a question that raised the interest and subsequent investigation of various institutions, as we explored earlier, such as the Reserve Bank and the Revenue Service, and in this instance was mostly based off the affidavit and further evidence provided by Arthur Fraser. The panel had concerns regarding the legality of the origins of the funds, with Arthur Fraser claiming that they were snuck into the country by a close advisor of the president named Benjani Chauke from other African and Middle Eastern countries without having been declared to SARS or the South African Reserve Bank. Both the president and Mr. Chauke have denied this version of events, with the president having produced an acknowledgement of receipt to corroborate his version of events, of this being the purchase price in the sale of buffaloes to a Mr. Hazim, a Sudanese businessman. The evidence provided by both the president and Mr. Arthur Fraser contained numerous questionable claims and significant gaps, consisting mostly of hearsay evidence or questionable documentary evidence and testimony. Despite this, the panel nonetheless found that the president had a case to answer for the origin of the foreign currency that was stolen, as well as the underlying transactions for it. In many respects, this conclusion and the recommendations that followed subsequently encapsulated many of the misgivings a lot of legal experts have raised with regard to this sectional 89 panel report. It was introduced by ATM, EFF and UDM as a supplement to the first charge on the basis that the presence of funds further illustrated that the president was involved in other forms of paid work. But the subsequent findings made by the panel don't quite appear to fall within that scope, in all honesty. Furthermore, the main source of the allegations was Arthur Fraser's statements to the SAPS and Public Protector, as well as the president's responses thereto. And although both essentially consisted of hearsay evidence whose source and veracity, as we've sort of alluded to already, remains untested, they used an invoice which raised numerous questions, more so than it actually answered. Even more so, the leaps in logic that were made by the panel with regard to the storage of the stolen funds was astounding, to say the least. They found that on a balance of probabilities and concluded that the funds were stuffed in a cutout beneath the couch, and there was no evidentiary basis whatsoever to reach this conclusion. It was all verging on speculation and conjecture. The panel went on to find that there was in fact a prima facie case for the charges made against the president, and that he had a case to answer for all four. However, similarly to the reasoning behind the recommendation in the sources of money portion of the report, Much of the reasoning and application of legal principles has left some lawyers really scratching at their head. So finally, we will explore some of these legal principles in relation to the judgment in order to understand what's got some of these lawyers so worked up and worried. There are certain legal principles that have been drilled into lawyers so much in their experiences of law school, articles, and practice that often when reviewing something we get an inkling of whether something is wrong before we can even really put our finger on it or our thumb on it. And often we have to take some time to consider what might be this issue and the legal principles being violated in an argument or judgment in order to reach some kind of definitive conclusion for our intuition. If any of you are fans of Spider-Man, you'll be aware of his spidey senses. And I think this is something similar to that. And as I was reading this document, this report, my legal senses were definitely tingling. But I couldn't quite put my finger on it initially, and that is why I engaged in this review. And after carefully reviewing the outcomes and the reasoning of the panel, as well as listening to some eminent legal scholars and names in the subject, I believe I've identified what some of these shortcomings may have been. I'll be using and explaining 4 legal concepts and ideas in order to more fully lay out some of these shortcomings readily apparent in the report. These include the concept of ultra vires, or acting beyond powers, hearsay evidence, inferences and probabilities versus conjecture and speculation, and finally the concept of onus of proof. Acting beyond powers, or ultra vires, describes actions taken by government entities that exceed the scope of their powers given to them by an enabling law. Some legal scholars, such as Richard Calland, have remarked the report may be vulnerable to judicial review because the panel may have exceeded its authority by considering evidence and matters that went beyond the perimeters or the outlines of the original impeachment motion that was tabled in Parliament. We discussed a good example of this earlier regarding the panel's findings and subsequent recommendations regarding the source of the money which was subsequently stolen. Next up, we have hearsay evidence. Now, this term hearsay evidence has been thrown around by many in the days since the release of this report. And fortunately, it has been codified into our law, and it is defined in the Law of Evidence Amendment Act as evidence, whether oral or in writing, the probative value of which depends upon the credibility of another person other than the person giving the evidence. Now, this essentially refers to evidence for which the person giving the evidence cannot directly account, but rather another person who provided that evidence to that particular person can, and often to prove must. In South African law, hearsay evidence is inadmissible unless proven otherwise, and may only be admitted in a very limited set of circumstances in the interests of justice. And this is done by considering a number of factors holistically that are set out in Section 3, subsection 1, subsection C of the Law of Evidence Amendment Act. And in short, these include: number 1, the nature of the proceedings. And with courts previously ruling that the quasi-judicial nature of inquiry should be considered in allowing hearsay evidence, I'm sure it would find some application in this instance. Number 2, the nature of the evidence. This primarily concerns the reliability of the hearsay evidence, looking at things such as whether the person testifying or non-witness have an interest in the matter, or whether it's against the interests of those people to provide the interest, etc. Number 3, the purpose of which the hearsay evidence was given. This means that hearsay evidence given for more compelling reasons, such as to exonerate, is more readily admitted than evidence for a doubtful or illegitimate purpose. Number 4, the probative value of the hearsay evidence. This factor compares the value of the hearsay evidence and its reliability with the potential prejudice or negative impact on the person whom it's given against. Number 5, the reason why it's not given by the person whose credibility it relies. In this instance, legitimate reasons such as fear for their life or retribution or subsequent death are usually taken into consideration. Number 6, the prejudice to the opponent that occurs should the evidence, or the hearsay evidence to be correct, should be admitted. Now, this is due to the fact that hearsay evidence is not subject to the same kind of reliability checks that the person whom it is against may also not be able to effectively counter inferences that may be drawn from it, So this definitely weighs in on the court's mind in thinking about whether or not to admit hearsay evidence. And all these factors have to be taken into consideration altogether before hearsay evidence may usually be admitted into a court of law. Now, the panel never engaged in this exercise, which of course is mandated by law, in weighing up these factors and considering what hearsay evidence should be considered and which should not. Now, this is very strange considering most, if not all, the evidence tendered by Mr. Arthur Fraser and of course the President, who are the main sources used in this report, was in fact hearsay or document evidence whose contents or sources were dubious at best. In fact, even more puzzlingly, the panel grappled with the problem of the extent of the hearsay evidence and explained, of course referring to the evidence of Mr. Arthur Fraser, that since they were unable to investigate, limited by the nature and scope of their powers, they believed the proper approach was to be satisfied that there is some other independent information which tends to support this hearsay evidence. This then leads me to my next principle of inferences and probabilities versus speculation and conjecture. Now, this principle in terms of case law is that they are to be positive, proved facts from which inferences may be drawn, without which what is left is speculation and conjecture. This has been further elaborated on that in making inferences, judges are to stay within the four corners of the proved facts, as they are not entitled to speculate as to the possible existence of other facts. The conjecture which the panel engaged in was mainly a function of their lack of access to information. This is partly because a number of investigations which would provide answers for much of the speculation remained incomplete, and as attested to by the panel, whose investigations left a lot more questions than answers from which it made its determinations. It is for this reason that I believe this process was triggered far too early, whilst much of the information required to properly consider the matter remains hidden. This could result in a troubling situation of Parliament proceeding with the impeachment inquiry whilst the bodies who have been investigating the matter find no case to be answered for. And finally, the concept of the onus or burden of proof. This relates to a party's obligation to persuade the trier of facts of the truth of certain propositions. The guiding principle regarding this onus is that the person making an assertion is generally called upon to prove it. In a number of instances, the panel did not consider any evidence proving the asserted charge, but rather poked holes in the reply of the President, declared it as insufficient, and proceeded to state that he had a case to answer for. We saw this with the first charge of him engaging in other forms of paid work, where statements and the reply of the President were used to assert that he dishonestly retained his membership of the operating entity of the Phala Phala game farm, when no evidence in that regard was tendered and no conclusive explanation of paid work could even be found in legislation or that in the panel's investigations itself. It is because of some of these shortcomings in law and logic that many have raised that there's a potential for success of the President's judicial review of the recommendations and conclusions of this report. Nonetheless, I believe that this was an important discussion and debate to be had, if not at least to set out the parameters and the procedure to be followed in impeachment proceedings. Ultimately, I believe what this panel and the recommendations and report they produce show to us is some of the downsides that can arise from a hasty approach to impeachment. A colleague of mine once said, "Extraordinary claims require extraordinary evidence." And having gone through this report fairly carefully, I'm not quite sure that's the case in this instance. Thanks for watching. Please like, share, and subscribe, and let's keep this debate going.